Mr. Dennis Tan.
Mr. Speaker, sir. The Workers' Party opposes the Protection from Online Falsehoods and Manipulation Bill, much as I believe that there is a need for some form of legislation to deal with online falsehoods, and the remedy must be appropriate. Indeed, the bill has generated much concern and objections from many Singaporeans since its first reading in April. I will share some of the concerns I have about the pro forma bill. As part of the conditions for the granting of the various directions under this bill, under Clause 4, the Minister must be of the opinion that it is in the public interest to issue such a direction, and Clause 4 provides a list of definitions or a set of different scenarios of what constituted in the public interest. I'm concerned with some of these definitions provided in Clause 4. I find them to be too general, and the precise scope is not clearly spelled out. For example, in the context of falsehoods, what does it mean to protect public health or public finances, or to secure public safety or public tranquility under Clause 4? What acts or words will definitively trigger each of these definitions? This brings me to the second point of concern about what is in the public interest. For Part 3 and 4 directions, a person who has been served with a correction or stop direction may appeal to the High Court against the directions after having first applied to the Minister. However, for both Part 3 and 4 directions, the appeal provisions expressly provide that the High Court may only set aside such a direction on 3 grounds of appeal as seen in Clauses 17.5 and 29.5. The issue of whether the Minister was correct or not in arriving at his opinion, that it is in the public interest to issue the direction itself, does not come within the 3 grounds of appeal and cannot be decided by the court on appeal under Clause 17 or 29. Similarly, the exact meaning and coverage of the definitions provided in Clause 4 cannot be decided by the court hearing an appeal under Clause 17 or 29. In this connection, the Minister mentioned the availability of judicial review yesterday. As things stand, the procedure and cost regimes for judicial review will be quite different from the procedure and cost regimes for the appeal procedure under Clause 17.5 and Clause 29.5. Does the Minister intend to apply the same cost, procedure, and timeline requirements for all court applications or appeal under POFMA, including judicial review? Would it not be better for the bill to expressly provide for the court's ultimate jurisdiction over all areas of the bill, including the issue of public interest, and for the same procedure and cost mechanism to apply? Finally, according to the explanatory statement of the bill, the list of definitions under Clause 4 is non-exhaustive. I'm concerned that in future, what else may be read by a Minister as a further definition or example of in the public interest. Still on Clause 4 of the bill, Clause 4F provides for one definition of doing anything in the public interest if the doing is to prevent a diminution of public confidence in the performance of any duty or function of in the exercise of any power by the government or an organ or state, a statutory board, etc. I believe that the diminution of confidence in government as a factor warranting legislative action is not found in fake news legislation elsewhere in the world. I am concerned that the extension of the definition of public interest to include not diminishing public confidence in the government may deter or prevent bona fide criticism and well-meaning intentions to expose genuine government failings. Above all, no government will always be correct, perfect, or beyond reproach. It is for the government, by its own efforts, to earn and maintain public confidence in itself, and any use of law to deter the diminution of public confidence will run counter to that. Next, the bill provides at Clause 2.2 the definition of a statement of fact and a definition of when the statement is false. Already, many commentators have said that the distinction between a statement of fact and an opinion may not always be easy to draw, not to mention the difference between a statement of fact and an opinion of a statement of fact. Different surveys using different parameters produce different outcomes. They may not all be wrong. They may even constitute statement of facts in different ways. But they prove that there can be divergence on what constitutes statement of facts. Under the bill, a statement is false if it is false or misleading, whether wholly or in part, and whether on its own or in the context in which it appears. This definition is troubling. The definition of if it is false or misleading, whether wholly or in part, whether on its own or in the context of what it appears under Clause 2.2 is too wide, especially the requirement of misleading alone. It would be misleading according to whose standards or opinion, and how would it be misleading? For example, if I were to say in good faith according to my own views, but say something in good faith according to my own views, but what if the minister or even the court decides that it meant something else, and it's different from what I've explained? I didn't even think of the minister's view when I uttered those words. Wouldn't that be very unfair to me, as I did not intend that meaning? Why should I be subject to his correction or stop directions? Why should I have to appeal to the courts? Shouldn't he apply to the court if he feels aggrieved in the first place? And the courts can decide in the first instance whether a correction or a stop direction is necessary. Next, according to Clause 2.2, an article can be deemed to be a false statement, even if only a part of it or a small part of it is false or misleading. Is there a risk that as a result of a small or even irrelevant or inconsequential factual error in an otherwise cogent article with serious issues, the article can be taken down, preventing the bulk of the meritorious arguments and issues raised in the article from being read and disseminated? I'm also troubled by the definitions of statement of facts, which have been defined as not false or misleading, rather than just false or false and misleading. Such definitions can be open to different interpretations. For example, if I were to tell someone that I made a police report against someone, in my opinion, that's a simple statement of fact, period. There's nothing much to agree or disagree or to dispute. I made the police report, surely I know that as a fact. But when one applies the definition misleading, what I have said may be interpreted by another to be something beyond what I ever intended to say or mean, and history has shown that such statements could be subject to different interpretations. And how would it affect articles or reports of an opinion nature which premises theories or findings on anonymous contributors? This could be by journalists or even academics. Those who have contributed their opinion or feedback, or even to a survey, may have good personal reasons for their anonymity, and not necessarily because they are, as a matter of integrity, afraid to stand up for what they have said. How would a journalist or newspaper able to challenge an order on appeal, given the circumstances? I fear that this new law will discourage journalists in their writings, particularly where the source of information cannot, for whatever reasons, be fully disclosed or cited in court. Next, to me, the most uncomfortable aspect of this bill is the minister being the first and even final arbiter under this bill. The Workers' Party object to the minister being an arbiter under this bill. We think that the minister in question should apply to the courts for an order under this bill and let the courts be the arbiter, the sole arbiter. Many in Singapore have voiced this concern about the government or minister being the final arbiter. The government has been saying that the courts are the final arbiter. Now, for Part 3 and 4 directions, that is only true insofar as any appeal comes within the three narrow grounds in clauses 17.5 and 29.5. If the courts are the final arbiter, why circumscribe and limit their powers in these ways? Why not let the courts be the sole arbiter under this bill? As I've said earlier, even the minister's opinion on whether the minister was correct or not in arriving at his opinion that it is in the public interest to issue the direction cannot be decided by the court when he hears an appeal under Clause 17 or 29. And even for appeal under the three grounds in Clause 17.5 and 29.5, it may only be true if the party being subjected to a minister order under this bill does in fact actually appeal to the courts. Until then, there is no judicial scrutiny. And if the party affected does not appeal to the court for whatever the reason, the minister order would have gone unscrutinized by the High Court, rightly or wrongly. Even when the appeal is pending, the bill expressly provides for the minister's direction to continue. Wouldn't this create injustice if the appeal was later allowed, proving that the minister was wrong in the first place? In such cases, if the aggrieved person has suffered damages, he may not even be able to claim against the minister. Further, in certain circumstances, a minister may potentially find himself in a position of conflict of interest when he invokes POFMA in respect of criticism or complaints of wrongdoing, either on his part or in respect of his own ministry. Is there a provision to handle such conflict of interest? Next, we do not have a freedom of information regime, and well-meaning citizens may not have the same access to information, unlike the government. And complaints may have arisen from well-meaning people where it may not be convenient to disclose the source of the information. In a situation where the government has access to certain information and for whatever reason refuses to disclose full facts in the first place, even on request, it would be unfair to penalize anyone arising from a media report or something discussed in social media. Significantly, the procedure under POFMA is different from the procedure in POHA, where the court there is truly the one and only arbiter. Any aggrieved person wishing to make an application under POHA applies to the court. If that works for everyone else, shouldn't the same procedure apply to the government in the case of POFMA? In my view, the courts should be given the exclusive rights to decide on any application under POFMA at first instance, and the court's jurisdiction should extend to all areas and issues under the bill. Next, I think that the same court should handle and decide both POHA and POFMA applications. This is not currently the case, as under the POFMA bill, the High Court hears an appeal against the minister's direction or order. On the other hand, applications under POHA are heard in the state courts. Without derogating from my earlier position that the court should be the only arbiter for POFMA, let me now deal with some procedural aspects of the bill. For parts 3 and 4 of the bill, if the affected person wishes to appeal to the court against the minister's stop or correction direction, he first needs to apply to the minister in question to vary or cancel the order. This seems odd to me, as I am rather circumspect that a minister will change his mind within a matter of days after his order. The additional step of notifying the minister is akin to being part of the appeal process itself, and will merely add time to the affected person's wait for the court hearing his appeal. But time may be of the essence to the affected person, especially when the minister's direction is wrongful and is bringing wrongful harm to the individual. In any case, I find the idea of, and in effect, appealing to the accuser to be a little odd. Next, in POHA, an aggrieved party applying for an order has essentially the burden of proving his case to the judge, deciding on whether an order should be given. In POFMA, the aggrieved party, in this case a minister or the government, does not have to prove to any authority or adjudicator when he first decides on a direction under the bill, such as a correction direction or a stop communication direction. Now, even when a defendant who is subject to a Part 3 direction feels that the minister is wrong in issuing such a direction and wishes to appeal to the court, the minister does not seem to have the primary burden of persuading the court de novo that it is entitled to issue the orders in question. In any case, this is not clearly or expressly set out in the bill. In both civil and criminal actions, it would be fair to say that the plaintiff and the prosecutor, respectively, bears the primary burden to prove their case in court. The burden of proof in an appeal under Clause 17 or 29(5) of POFMA appears to be on the person who is the subject of a minister's directions under POFMA. This should not be the case. Surely the minister and government, as the aggrieved party, must always bear the burden of proof for any direction or order under POFMA. In closing, the minister cannot be an arbiter for any order or direction under POFMA. The courts should be given that role exclusively. Like many Singaporeans, I fear that the bill, if passed, will create a chilling effect, whether for journalists, legitimate interest groups, academics, or the average Singaporean. It may deter people from speaking up. It may encourage journalists or academics to err on the side of caution for falling foul of the law. If a minister or the government is not forthcoming in providing clarificatory facts, it may encourage journalists or even common citizens to practice self-censorship at the expense of truth. It will discourage bona fide criticism and stifle public debate. Along with my Workers' Party colleagues, I do not support the bill.